Okay, so I will be discussing Section 82 of the Evidence Act. This is because this is a very crucial provision in the Evidence Act. It's very, very important. It's something you meet every day in court. And in the course of this study, I have discussed documentary evidence and the requirements of proof admissibility of documentary evidence. It's one of those very important provisions that one needs to know when you talk about proof of documentary evidence, especially as it relates proving a fact in issue which is in documentary form. And you recall we did say that the best oral evidence is the evidence of the person saw, heard, or perceived the evidence relating to fact in issue. Now, Section 83 deals with similar evidence, just exactly the same thing, but under Section 83, the person who saw, who perceived, or who heard directly, direct hearing, here is not giving us oral evidence. He is doing what? Giving us documentary evidence. Now, this provision is very important to guide against what is called documentary hearsay. You know, when we talk about oral hearsay evidence, it simply means when I repeat what some other person told me, I didn't, witness the incident myself, but I was told, and I'm repeating it. So if I'm repeating it to another person, what am I doing? I am relaying what hearsay evidence. So the same thing happens documentarily. There is something called documentary hearsay. If somebody is relying on a document, maybe he wrote a document to his friend, and I want to use that document to prove that he told his friend a particular thing. As I look at the document now, he told this man that so thing will happen. The question will be, am I competent to tender a document made by someone else, recording account of what he saw or what he perceived? The answer is what? Is no. Why? Because if I do it, it will amount to what? Documentary hearsay. So just like you have oral hearsay evidence, you also have what? Documentary hearsay evidence. So we'll look at the fulcrum of Section 83 to discuss the purview of the rule against documentary hearsay. Now it provides in any proceedings, I'm going to also address this usage of words, because by Section 91 of the Repealed Act, so the word used there was in any civil proceedings. In any civil proceedings. But Section 83 here is saying in any proceedings. So it's not limited to civil, which means this provision applies both to civil proceedings and what? Criminal proceedings. In any proceedings where direct oral evidence of a fact will be admissible, any statement made by a person in a document which seems to establish that fact shall, on production of the original, be admissible as evidence of that fact if the conditions are satisfied. Now, before looking at the conditions, what is this place talking about? It's simply saying that if somebody who saw something, who perceived, who has direct evidence, decides to put it in writing, now that write-up will be admissible as a direct evidence, so long as it is being tendered by that person who made it. And then also, that what the person is tendering is what? The original document. In other words, take it again, the document that the person seeks to tender must have been the document that he did what? He authored by himself. And what he has written there will be what he saw, what he observed as an occurrence, and not what he was told. Now, this document must satisfy this requirement in order to be admissible under Section 83. And then further, it's talking about the conditions for the admissibility. One of the conditions I've already mentioned is that one, if the maker of the statement, the person tendering must be the maker of the statement. The person tendering the document must be the maker of the statement. I'll also give us examples, especially in criminal proceedings where we normally have issues like this, especially police records and so on and so forth. He must be the maker, and he must have personal knowledge of the matters contained in that document. Now, subsection 2 is talking about something else, maybe something that looks like an exception, where this person who is tendering it is not the maker. Now, what would be the condition? Assuming this person works in an establishment, let's say a banker. Somebody is working in a bank, and there is a document you make there while you're working. Maybe they will tell you your duty, you're a teller. Your duty is to be recording cash in, cash out. Right. And as you're recording it, maybe you will continue from where Mr. A stopped. Right. And if for any reason there is need for you to tender the evidence of your predecessor in office, which is documentary, and you were not there when he wrote it, subsection 2 allows you, but upon condition. What are the conditions? Where the document in question is or forms part of a record purporting to be a continuous record made by the statement insofar as the matter dealt with by it are not within his personal knowledge, but in the performance of a duty to record information supplied to him by a person who had or might reasonably be supposed to have personal knowledge of those matters. Now, the condition is, if I'm working in a bank, I've been employed in a bank, and I'm to tender document written by Mr. A. You know, document written by Mr. A is not my document. Now, for me to beat the requirement of documentary hearsay evidence, I must show that Mr. A authored the document, and he authored it based on the facts within his knowledge. I may not be there. And that's why this place uses a presupposition. It's either I know or I must be in a position to take him as having had the prerequisite knowledge to prepare that very document. So don't be confused about these two things here. If I want to tender a document, I must be the maker, right? But if maybe I'm employed in an establishment and there is need for me to tender a document, the document I'm tendering must be related to my duty. I must be made by somebody else, not me. And that person who made it must have had knowledge, or he must have been presupposed to have knowledge of the document he made. So in such a circumstance, I can be allowed to tender it. Who knows why this exception is given here? Can you think and tell me, why do you think that the law is a bit liberal when it comes to corporate documents here, corporate records?
Because companies are artificial persons, they don't have hands and limbs of their own, so they act through their agents.
They act through agents. Any other thing?
Artificial persons have this character of perpetuity.
Character of perpetuity. So if you start waiting for that person to come and tender it, maybe they have already sacked him. You may come there and spoil the case of the bank. Am I right? You know, you just simply come in and find one way or the other to wreak vendetta on the bank. So that's why this provision says, soldier go, soldier come, but the barrack remains. So that's exactly what this subject is talking about. Then when we go to section 831B, you see another thing here. And this place is saying, if the maker of the statement is called as a witness in the proceedings, provided that the condition that the maker of the statement shall be called as a witness need not be satisfied, we'll talk about it. So what I have tagged sub B is exceptions to the documentary hearsay. Section 81, subsection 81B, section 83, subsection 1B of the Evidence Act is exception to the documentary hearsay evidence. Now, this one doesn't have to do with the corporate body. Sub II does with corporate body, but this one does with issues generally minus corporate body. It's saying that the requirement that the document must be tendered by the maker can be dispensed with under the following circumstances. Do you understand? Which means the circumstances I'm going to call out now are what? The exceptions. And these include, one, where the maker is dead. Of course, a dead person is can be a witness now. He will not be useful to any court proceeding. So when someone is dead, a person who is living can do what? Tender that document under this as an what? Exception. Because there's no way you can call him back. And it may as well be that the document made by this person is so relevant to the case. It may be something that will determine the case. But this person is dead. So if you insist that he dies with the document, it means that you are doing what? Foreclosing evidence. So that's why this place is giving us this exception as one of the exceptions to documentary evidence. As it relates to what? Private persons, not corporate bodies. Try to distinguish and mind the two. They are very, very important. Then two, if the person is unfit by reason of his bodily or mental condition, if the maker is alive, but he is not fit to come to court to testify, either because of bodily infirmities or mental incapacity. So when that happens now, you can't say that he must come to court. I mean, you will be, creating a situation of impossibility now. Assuming the person has gone mental after having made that document, it means that you want to now use somebody who is not in lucid moment to do what? To give evidence that he made when he was lucid, and there's no way it will balance. Right, so that's which stands out now as the second exception. And then the next one is where the witness is outside Nigeria. Where a witness is outside, and when you look at this exception, I begin to wonder whether this provision is not in contradiction to the intention of Section 84 of the Evidence Act, which talks about computer-generated evidence. So if in this modern world that we can receive computer-generated evidence, why would you draw a barrier? I said because somebody is abroad, who will not require him to give evidence directly. Is it impossible? Is it impossible? It's not. It doesn't need to come down. We can use virtual proceedings. We can even use Zoom. Even though if we try to use audio, it may be doctored, right? But there are things that can be, other facilities that are available that can be used. So what I'm trying to say in effect is that this very condition shouldn't have been here. This exception is not encouraging technological breakthrough. It's not encouraging virtual proceedings. If we simply say, let another person tender the document because this other person is abroad, I'm going to tell you the danger of creating this type of exception. That the person is abroad and that is impracticable to secure his attendance, or if all reasonable efforts to find him had been made without success. This one stands on its own. A person that you have found and you couldn't find does not necessarily mean that he's what? Abroad. Doesn't need to be abroad. If a witness is required and you can't find him, after making frantic effort to reach him, and you have failed to reach him, it means that you can do what? Get another person to tender the document under this provision. All you need to do is to do what? Tell the court, I looked for him and I could not see him. The dangers of these exceptions. A non-maker of the document may not be able to answer when you turn it the other way around. He may not be able to answer questions on the document. I need to ask you, I remind you, you are not the maker. You say, yeah, you are not the one it was made. And not being there, you didn't know what happened. You keep telling me, yes. What have you answered? Nothing. Right. So that's one of the dangers. You will not be able to answer questions based surrounding the document that he has tendered. And that will render the way to what? Valueless. Okay, now we'll move over. We are getting close to why I chose this provision now. We're getting closer. And then we'll go over to subsection 2 to see something different. Subsection 2 of section 83. I call this one now the discretionary provision of the court. Section 83, subsection 2 is the discretionary provision for the court. And it says, in any proceedings, the court may, at any stage of the proceedings, if having regard to all the circumstances of the case, it is satisfied that undue delay or expense would otherwise be caused, other than such statement as is mentioned in subsection 1 of this section, be admissible as evidence, or may, without any such order having been made, admit such a statement in evidence, notwithstanding that the maker of the statement is available but is not called. Maybe you have looked for this person and you couldn't find him, and you have someone else to tender the document. So the court, apart from what may transpire under subsection B of subsection 1 of the section 83, the court cannot fall back to section 83 subsection 2 to do what? Exercise its discretion. If you have said this person is abroad and it is determined he is alive, right, but it will cause undue delay for us to wait for him to buy tickets, especially now that dollar is something else to naira, and it will entail so much hardship because we say, I will admit the document. Now, when you go home, look at section 83, subsection 1b, compare it to section 83, subsection 2, and tell me if it made any difference. Now, section 83, sub 2 has two arms, A and B. I've told you the first arm is that the court may use what? Its discretion to admit the document. If the court feels that it will entail hardship or undue delay to start waiting until we find this person who is elusive, the court can simply do what? Admit the document. Now, this says original document, where the original document is not produced. If in lieu of it, there is produced a copy of the original document or of the material part of it certified to be a true copy in such a manner as may be specified in the order or as the court may approve, as the case may be. Now, simply put, the court also has a similar discretion under sub B of section 83, subsection 2. Here now, the court can dispense with the original document and admit what? Secondary evidence or certified true copy. So these are the two documents the court can admit under this provision. And you know, this provision has treated CTC as if it is no longer an original document. And that's why I told you last time that there are the Evidence Act, most provisions of it is replete with that confusion as to whether CTC is what? Original document, whether it's a primary document or secondary document. Why it is like this is because most of the times, the original document of a public document may just be one in the custody of the powers, the government. And they will not want to release it, because if they release it and tender it, it may get lost. And that means the end of the road as far as that very information or evidence is concerned. So that's why the law requires that in a public document you can do what? Obtain the certified true copy and tender. So when a person who is not the maker of a document is in the court and is not even having the originals, the court can rely on section 83, subsection 2A to admit it. And then in subsection 2B, the court will now say, since you don't have original, you can tender what? Secondary evidence or the certified true copy of it if that document is what? A public document. Now, going further, subsection 3 says, nothing in this section shall render admissible as evidence any statement made by any person interested at a time when proceedings were pending or anticipated involving a dispute as to any fact which the statement might tend to establish. Simply put, to summarize subsection 3. Subsection 3 now foresees a situation whereby I may decide to do a broker if I begin a matter with you, forge a document when a case is already pending, and then I discover that my case has a loophole. There is need for me to bring a document. Let me, for instance, say I'm doing a matter, and in that matter, an elder brother made a gift of land to the younger brother without documentation. You know how it is in our tradition. Somebody giving you land free of charge, you may not have the mouth to say, uncle or brother, put it in writing. Do you understand? He may get angry and say, I'm not giving you a gift. Right. If, for instance, because there are live cases like this, you are doing this matter, maybe this man had already died, and the children are grown up, and they are saying, our father simply asks you to stay on this land, and when we grow up, you give it back to us. It sounds convincing, isn't it? But because they were not there, they may not know that their father made a gift of it. Even if they know, they may decide to be what? Very mischievous about it. You understand? Now, for the person who is on the receiving end, he may be forced to go and write a document saying that these children may sue me tomorrow. He quickly prepares a document purporting his elder brother to have signed. This provision is saying once there is a document is proved to be of that nature, it becomes what? Inadmissible, because it has the foundation in what? In fraud. It has the foundation in fraud. Or maybe a case is still going on, and somebody said, and maybe you never knew they were going to ask you the question. You said that you bought so something. It was not a gift to you. He said yes. When you bought it, were you given a receipt? You say yes. You have the receipt in court. You say no, my lord. And during the next adjournment, you quickly mold a receipt. I said, my lord, the other guy, I forgot it. I now have it in court. So if it can be proven that this receipt was prepared when the case is still going on, that receipt becomes what? Inadmissible in evidence. Two things here, either when the case is pending or when the case is anticipated. Any document prepared to boost you prove your case will look like overreaching the other party, and the court will rule that such a document is what? Inadmissible. So long as the party disputing it can prove that it falls under this very section of the Evidence Act. Subsection 4, for the purposes of this section, a statement in a document shall not be deemed to have been made by a person unless the document or material part of it has been written, made, or produced by him with his own hand, or was signed and issued by him
or otherwise recognized by him in writing as one of the accuracy of which he is responsible. Subsection 4 is telling us how to be a maker of a document. When can it be said that a document has been made by somebody? One, when the person actually produced it, made it by himself. Production here should simply say, hey, Mr. Joe, this is it. I'm reading something, I have produced a document. Or when a document has been produced, maybe he asks his friend, help me do this, prepare it, and he does what he signs. Or he initials it. We cover 3 grounds now of how to be a maker of a document. Or finally, when he does a document saying, I was the one who authored this other document. If this person gets up one day and writes, and the person who wrote that document, you are looking for the owner, that person qualifies as what? A maker under this provision, whether he wrote it or not. Whether he's the one who wrote it or not. And when you look at this, you begin to wonder, is it not possible for somebody to now claim what he is not? And when he is allowed to do that under this provision, is it not prejudicial to the other party? So when you are discussing things like this, you need to look at the 2 sides of the coin. And now, finally, subsection 5. For the purpose of deciding whether or not a statement is admissible as evidence by virtue of this section, the court may draw any reasonable inference from the form or contents of the document in which the statement is contained, or from any other circumstances, and may, in deciding whether or not a person is free to attend as a witness, act on a certificate issue. 2 things are involved in subsection 5. The first one is when a court needs to determine whether a statement was made during the pendency of a suit, or whether a statement was made in anticipation of a pendency of a suit. You know, the court is not a spirit. So the court is to be guided by the contents of that letter, of that document. That is one. Or the form in which it has been prepared, or the circumstances surrounding the making of the document. For instance, now like I had said, you were in court the first day, you did not plead that you bought something and you were issued with receipt. You didn't plead it. And you never knew it was going to be an issue. But you came to court and the issue arose. And you were asked, do you have the receipt? You said no. And all of a sudden, the following day, you said, my Lord, I have the receipt. So you discover that that circumstance is what? Is doubtful. Is doubtful in the sense that if you had this document had been issued, why didn't you plead it? You understand? You should have pleaded it and you should have done what? Attached it, front-loaded it to either statement of defense or statement of claim. So the court can consider the circumstance, the contents of the document or the form and say, no. This was made because of this case. Alright. There's this case where somebody's vehicle was damaged. He went to a mechanic, you know, when the lawyer had already written, we want you people to, within so days, repair this vehicle or give us the value of the vehicle. He went to a mechanic who wrote a bogus receipt, telling I bought this, I bought that, you know, all those kind of things. And he came to court to prove that maybe this, the damage could have been something, let's say, 5,000 will repair. And somebody is claiming 500,000 naira. So the judges, being human beings, can look at the circumstance and say, this receipt was prepared for what? For the purposes of this very case. That is the form. The court will now consider the form of the document. You know, and to know fully well that maybe ordinarily looking at the circumstances, this couldn't have been possible. Alright, so this is all about section 83, and I told you that the major purpose of section 83 is to do what? Guide against documentary hearsay. So So when you look at the numerous exceptions here, you begin to wonder whether this provision really stands for what it proposed to stand for, or whether these exceptions have done what is done so much so that it has become like a fluke, so one can not actually trust these provisions, because the idea is to make sure that the only person who tenders a document is who? The maker of the document. But when you have all these exceptions, so you don't have situations where that document can simply go in without the maker being the person doing what? Tendering it. And then on the reverse, like I have said, the person tendering it may think that he is smart, right? But on the other hand, he may not be able to do what? To defend that very document. And that will invariably affect the weight of the document. When